In this video, we're going to be looking at removal of trustees, and we've already had a little look at the appointment of trustees in terms of like the appointment by the court, appointment by the trust instrument itself, for example, and we've had a look at the replacement of trustees. And so this leads us on to a discussion about the removal of trustees. So, trustees may retire or disclaim the trust if they so wish. However, where a trustee becomes incompetent owing to the following criteria, but does not voluntarily retire, they may be removed from office, and that is mental illness or bankruptcy. So if you can't handle your own finances, then you shouldn't really be handling the finances of a trust, or they remain out of the country for more than 12 months. So just to reiterate, if a trustee becomes incompetent owing to any one of these three things, but does not voluntarily retire, they may be removed from office. Now, this may be done by the powers conferred under the trust instrument, in other words, an express provision in the trust that gives the power of removal to someone, or by the powers under section 36, subsection 1 of the Trustee Act 1925, and that is by the trustees themselves. So removal by the court. Now the court may intervene where the existing trustee refuses to go or where the trustees are in dispute. A court may also remove a trustee for breach of trust or improper conduct, but the principles on which it will exercise this jurisdiction are somewhat vague. So if a trustee is in breach of its duty or conduct, the court will very willingly remove them. Now, in Stoneham Settlement Trusts, in this case, a trustee who had been abroad for more than 12 months was unwilling to resign as a trustee. The court held that the other trustees could force his removal, and that in so doing, the trustee could play no further part in the appointment of his successor. So, being gone for more than 12 months is one of the conditions on which a trustee can be removed, as we just saw in the previous slide. The court said absolutely that the person could be removed and the removed person could not aid in the appointment of the new trustee that takes his place, okay? In other words, his opinion doesn't matter. We also have this case of Letterstedt, and I would recommend that you read this case. It's quite an important case to read. Now here, the beneficiary made allegations of fraudulent breach of misconduct in the administration of a trust against the trustees, and the allegations of fraud and concealment were not substantiated. High contention between the beneficiary and the trustee. So here, the beneficiaries said the trustees were doing things wrong. Okay, they said that there'd been some misconduct in the trustees' administration, so they wanted to remove them. Now, the case concerned the will of Letterstedt, who owned a successful brewing business in South Africa, and he declared a trust in his will in which he left the business to his daughter. Until she reached 25 years old, the trust of the business was to be administered by a board of trustees, and the business itself by a manager. The daughter was to be entitled to 2/3 of the profits of the business until she reached 25. And she brought an action as she believed the board of trustees had taken too much for themselves, and she claimed just over £28,500. Importantly, she also wanted the board of trustees replaced by new trustees, as she had lost confidence in the current trustees. Now, the issue for the Privy Council was in what circumstances the court should exercise its inherent jurisdiction to replace trustees, and whether the trustees of this particular trust should be replaced. And we have this quote from Lord Blackburn, who said that, therefore, though it should appear that the charges of misconduct were either not made out or were greatly exaggerated, so that the trustee was justified in resisting them, and the court might consider that in awarding costs, yet if satisfied that the continuance of the trustee would prevent the trust being properly executed, the trustee might be removed. It must always be borne in mind that trustees exist for the benefit of those to whom the creator of the trust has given the trust estate. So the court said that they could not find any misconduct that the beneficiaries are talking about, but because they are obviously arguing a lot, and therefore the trust is not functioning, the trustee needs to be removed. So there is not an issue with misconduct, but because they are bickering so much, the trust isn't functioning and therefore the trustees have to go. So on the facts of this case, it was found that it was in the best interest of the beneficiaries to order the removal of the trustees. The beneficiary had not proved that the trustee had acted fraudulently towards her by taking such sums from her entitlement and failing to ensure that the accounts were independently checked. Nonetheless, the relationship of trust and confidence which had to exist between a trustee and beneficiary had broken down. So it was in her interests that the trustees be removed from office. Now, out of this case come some basic concepts. Okay, so the following what I'm about to show you is all the big things that came out of the case, hence why it is important to read the case itself. And the case establishes a lot of points about when we can and cannot remove trustees and why it is occasionally important to remove trustees in a trust. And so these are these points, and the first one is the court's main guide is the welfare of the beneficiary. So even if they are, being snots and not being great beneficiaries, it doesn't particularly matter per se because they are the beneficiaries. Okay, this was the settlers' wish, so they will have the priority. The court makes this very clear that this is their main guide when exercising so delicate a jurisdiction as that of removing a trustee. The second point that came from this case is that in cases of positive misconduct, the court will have no difficulty in removing trustees who have abused their trust. So if the trustees are breaching their duty, the court says this is clear cut and they will remove the trustees. The third point is it is not every mistake or neglect of duty or inaccuracy of conduct of trustees which will induce the court to remove the trustees. The trustees' acts or omissions must be such as to endanger the trust property or to show a want of honesty or a want of proper capacity to execute the duties or a want of reasonable fidelity. So just because you suck at your job doesn't mean you lose it. So there has to be something more than just being a bit incompetent. There has to be that breach of fidelity or confidence that comes from that fiduciary relationship and is instilled in the trustee relationship. Now, the fourth point is that the removal will be appropriate when the continuance of the trustee would prevent the trust being properly executed. So the removal of trustees can occur even when there is no misconduct if keeping the trustee in place prevents the trust being properly exercised. And finally, the fifth point is that friction or hostility between trustees and beneficiaries is not of itself a reason for the removal of trustees. So this has gone beyond bickering in this particular case, or Letterstead. However, it should not be disregarded if the hostility is grounded on the mode in which the trust has been administered, such as where it has been caused wholly or partially by substantial overcharges against the trust estate. So really, we have to make sure that there is a serious amount of bickering, as apparently was the case in Letterstead. Now, another case on the removal of trustees that you ought to look at is this case of Wrightson and Cook. And this case recognised what was stated in Letterstead and said that it is possible to remove trustees even when there is no misconduct. However, the case also recognised there was a secondary difficulty with the expense of removing trustees and appointing new ones. Okay. Now, in this case, the trustees of land had, according to the beneficiaries, effectively invested the trust fund in an investment which was not authorised according to the terms of the trust. Now, the beneficiaries brought an action seeking a declaration from the court that the investment was in breach of trust and wanted relief from it, and this was duly granted. In a later action, some of the beneficiaries also sought the trustees' removal from their office. Now, taking into account the trust had very little money, the process of removing and replacing trustees would almost deplete the trust fund. Warrington, the judge here, held that it was not in the beneficiary's best interest that the trustees be replaced. So even though the trustees in the case were clearly in breach of trust, they were not replaced, as the welfare of the beneficiaries was the overriding concern that could trump every other issue, as was stated in Letterstead. So in this instance, the court said that the trust was not operating very well, but at least it still had money, okay? But if they allowed the removal of the trustees at this point, it will lose its money, and then that will really defeat the purpose, okay? So this case says that although trustees can be removed when they are bickering with the beneficiaries to an extreme degree, as was stated in Letterstead, but if there is very little money and it is going to cost a lot, they will still want to protect the trust property. So ultimately the cases are the same, Wrightson and Letterstead, in protecting the trust property, but they had different results. And this is something that Warrington J was saying here in this quote. And finally, with regards to removal by the court, we have the case of Rubin and Rubin from 2001. And in this case, the trustees threatened to exercise a power of appointment in favour of the life tenant if the remainder beneficiaries did not discontinue their inquiry about the trust property. So this is a blatant misconduct trying to bribe your trustees. This is a clear breach of trust and confidence. So the court exercised its jurisdiction to remove the trustees. And also with respect to removing trustees, we have this concept of conflict of interest, and I refer back to the case of Isaac and Isaac, which is something that we did look at in a previous video, but I'll go over the facts of the case again. So in this case, the managing director, Mr. Isaac, of the company was a shareholder in his own right and was also a trustee of a family trust, which also had a large number of shares in the company. Now, what happened was that a large national building firm, Travis Perkins, was looking at buying the company. The beneficiaries of the trust were very keen for this to happen because the managing director was not distributing the profits, but putting it straight back into the business and not declaring a dividend. So although the beneficiaries of the family trust were on paper had a lot of capital, they were getting no benefit because no dividend was being declared. And it's also quite difficult to sell shares in a private company. So the beneficiaries under the trust were extremely frustrated that even though there was a huge trust fund, they were seeing no benefit from it. So they were keen for the company to be bought and their shareholding to be converted into a publicly traded company like Travis Perkins, which would give them a yearly dividend, which would give them an income from their trust fund. But the managing Mr. Isaac decided to ruin or scupper the deal, okay? Travis Perkins said that they would only go through with the deal if 75% of the shareholders approved it, and Mr. Isaac, by voting his own shares against Travis Perkins' acquisition, prevented the deal from continuing. So the beneficiary of the trust, the beneficiary sued for the breach of trust, saying he is obliged to act in the best interests of the beneficiaries, and said that their best interest would clearly be furthered by selling the company. Therefore, he should have voted his own shares in the beneficiary's interest. Now, the court disagreed. He could deal with his own property for his own benefit. So in these circumstances, when dealing with his own property, he can act to his own benefit. So although there is a conflict of interest here, it is a declared conflict of interest, which is okay. And the judge Parkes as respects his personal shareholding, he was entitled to make up his own personal mind about whether he was interested in selling to Travis Perkins, and he was entitled to reach his decision about that uninfluenced by the fact he was also a trustee of the family trusts. So it was held that the defendant, in dealing with his own shareholding, was entitled to act in his own interest, and that he was also a trustee did not mean that he had to take the beneficiary's interest into account when deciding how to proceed. So he could make his own decisions. He could make this decision and separate his trustee and beneficiary responsibilities. And finally, we have public trustee and Cooper. So if a situation arises during the continuance of a trust where one of the trustees might be considered to have a conflict of interest, it does not necessarily or usually follow that he must resign as a trustee. The extent to which he can properly participate in the trustee's deliberations about what to do might be affected by his conflict, but he can certainly continue as a trustee. So this just reiterates the case we just saw. In other words, just because there is a conflict of interest doesn't mean there is going to be a removal of the trustee. The court will give you the benefit of the doubt. Okay, so that is the end of removal of trustees, and that sort of finishes the sort of first main segment about trustees and the sort of administration side of them in terms of how you can get appointed, how you can get replaced, and how you can get removed. And in the next video, we're going to be talking about the trustee powers. What powers do trustees have? But if you have any questions about this particular video, then leave a comment below and I'll get straight back to you. If you enjoyed the video, make sure you give it a like and subscribe to my channel. Thank you very much for watching.